If
Oh,
you're Bryan Kohberger's lawyer, what is your next step? Because they've kind of said in the past, this is going to trial. I mean, what do you do? Do you explore any options? Like, all this stuff is coming in. Do you explore any options? Like, do you go to the prosecutor and say, "Hey, would you take the death penalty off the table if he just agrees to life without parole?"
precisely. You work up the mitigation now because I think he really is sunk in the guilt phase.
Is it me, or does this moron look like he's been dead for 3 years already?
Like you, be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And you know, folks, in this case, things are now starting to become more and more clear. I was wrong with my assessment yesterday of the neuropsychological and psychiatric experts on being OCD or ADHD. Some of y'all out there have been right for a long time. So it's autism spectrum disorder is what they diagnosed him with. And that is going to be key because that answers so many questions. One of the questions that it answers is that medical information that kept getting brought up over and over. It's also answering the question of one of the reasons that they are going to try to get the death penalty removed. And it answers questions on one of the reasons why law enforcement thought they could get a conviction with Bryan Kohberger. And I'll be explaining all of that in this video. And it's important for me to get this one out early and first because we've got to preclude the myriad of mainstream morons and guilters out there that are going to be running with this narrative, I assure you. So, and I know they're about to run with it hard because a simple Google search will tell you that almost every news outlet around is jumping on the autism thing. And it's not going to be a good thing in the media, I assure you. When you watch this video, you're going to know why. But what I want to do is I want to make sure that we're all educated on this subject. I'm going to point out some of the strategies that Ann Taylor is employing. And then I want to make sure that we're all on the same page for why we believe what we believe. You got to remember, I do not advocate for Bryan Kohberger's innocence in this because I feel like Bryan Kohberger's a good guy, or I feel like he couldn't, have done this or wouldn't have done this or any of that stuff. No, I advocate on Bryan Kohberger's innocence because I have been shown enough evidence that proves that he couldn't have done it. Right. These people out there that say, well, I just hadn't been shown enough evidence to convict the guy yet. Give me a break. You've been shown more than enough evidence to know that he couldn't have done it. All right, he couldn't have done it. The evidence has shown that they have given us and leaked has shown that he couldn't have done it. And I'm going to reaffirm that in this video once I educate you on what's going on in this process. Because we got to be doing this stuff for the right reasons. It's not because we think Bryan Kohberger is a good guy. I'm sure he is a good guy. Maybe he's not a good guy. I don't know, but I know the facts in the case determine that he couldn't have committed this crime. That's what I know. So the first thing I'm going to get into is some of the procedure around what Ann Taylor has just done. Because I firmly, and you for those of you that have been watching me know that I've said that, and I thought it would happen after the motions in limine, but it's happening now. I thought that she would file what's called a motion for sanctions to get rid of the death penalty due to the lack of discovery. Well, instead, she has filed a motion to preclude. And it's very interesting, and I've tried to research it as much as I can to try to understand the strategy with a motion to preclude rather than a motion for sanctions. And I'm still not quite sure of the strategy. So if there's any high quality Idaho attorneys out there that understand why you would do a motion to preclude rather than a motion for sanctions, please let me know in the comments below, because I sure would like to know. So I'm going to go through and we're going to talk about that first and give you an idea. I'm not going to go through. There's a ton of stuff on the case summary. I'm not going to go through and try to determine what that stuff means, because that would just be a needless speculation until I see those docs post to the court record. Because there's a whole bunch. This case is getting crazy right now. But I am going to discuss the things that that I'm fairly certain of, and that relates to the autism spectrum disorder, what's been going on in these hearings that relates to it. Why that's important, and why it's also important to get out in front of some of the bad press that's about to come. So with all that being said, let's look at the case summary as it relates to these motions, and then we're going to talk about sanctions versus preclude real quick. Let's do it. Okay, so when we go to the case summary, you're going to see right here, first of all, she's got a motion for leave to file additional motions challenging the death penalty. The reason she has to file a motion for leave, remember 24th was the deadline, so she had to get all these in on the 24th. So she files a motion for leave because the death penalty motions have already been filed and the hearing has already been held and the rulings have already come down for the judge. So she has to file a motion for leave because that is already passed to be able to file additional motions challenging the death penalty. And then she's got a motion to exceed page limits, and we won't talk about that one right now. But the motion for leave, I believe, is so that she can file this same motion right here, and it's the motion to strike the death penalty because of autism spectrum disorder. Now, this motion to preclude, I don't believe she has to get the leave granted for the motion to preclude. But I do believe she has to get the motion for leave granted to be heard on the motion to strike the death penalty due to autism spectrum disorder. So, but this motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. This is the one that I've said in the past that I knew it was coming. I've said it, if you watch my videos, you know that I've said many times I've been waiting for her to ask for the death penalty to be removed due to lack of discovery, because there is recent precedent in Idaho with the Lori Vallow case. And I've said for a long time that this is exactly what they're going to try to remove the death penalty with in the end because of the Lori Vallow case. And it was the fact that the state doesn't, disclose all the stuff to the defense. They've got videos. I've got a whole list of that disclosure, that they have not got, and they may have stuff that I don't even have on the list that I don't know about. But it's numerous violations, and a lot of it's video, and video that they know they collected. So that is, and the fact that they have, Brady Giglio material of the law enforcement involved in this case hiding video in the past really lends to, the severity of the situation as it relates to law enforcement not giving over these videos that they should have had, because those videos are absolutely exculpatory. So, but she filed a motion to preclude instead of a motion for sanctions. And I'm just curious about that, because when I look at some of the research that I've done, you can see that a motion for sanctions is not the same as a motion to preclude. While both are legal motions filed in court, a motion for sanctions asks the judge to impose penalties on a party for violating court rules or engaging in improper conduct, while a motion to preclude asks the court to exclude specific evidence from being presented at trial due to procedural issues or inadmissibility. So I'm just not 100% sure what the strategy is with the motion to preclude, because again, the motion to preclude seems to lend to excluding of evidence. Well, that's not what she's asking for in in the motion. She's asking for him to remove the death penalty, not exclude evidence. So it's got me kind of puzzled. And you see, a motion for sanctions aims to punish a party for misconduct, often related to discovery or filing frivolous claims, while a motion to preclude seeks to prevent specific evidence from being used at trial due to legal reasons. And then we got outcome. A successful motion for sanctions could result in monetary penalties, attorney fee awards, or even dismissal of a case, whereas a successful motion to preclude would simply prevent the designated evidence from being presented. So, if a motion to preclude to remove the death penalty is possible, then I can understand why she would go this route versus a motion for sanctions, because this judge doesn't seem to be very apt to penalize the state for misconduct. He seems like he would be more apt to award the decision based on procedural violations. So not necessarily that they did anything wrong, but more to the point that they didn't, they just didn't fulfill all their obligations. So that may be the strategy there, but I'm just not sure. But either way it goes, she's filed a motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Now, why is that important? Now, for some of you that haven't been with me for very long, let me explain something to you that's very important to understand. Because you might say, well, why would they even care about the death penalty if they know Bryan Kohberger's innocent and they feel like they can win at trial? Because if the death penalty is on the table, and this has been brought up in the hearings many times by the defense, if the death penalty is on the table, then the jury that must be seated to hear the trial is 2 or 3 times more likely to convict during the guilt phase. So looking at the evidence, they're more likely to convict than a jury that is not death penalty qualified. For them to be death penalty qualified, they have to be okay with somebody receiving the death penalty, which typically puts them in the category of somebody who believes the state above all else. So, and that is what research has shown in the past. So it's very important for the defense to get the death penalty removed from the case before they try to seat a jury, so that they can seat a proper jury that will objectively look at the evidence and rule based on the evidence in the case. With a death penalty qualified jury, that stacks the deck against the defense even more. So this is very important, and I've been waiting for the motion to remove the death penalty for the lack of discovery for a long time. So, and I think this is the best chance that they have, because even Judge Hippler said in a hearing several months ago that he brought up the Lori Vallow case, the fact that they didn't get the discovery and the fact that they got the death penalty removed because of that. And whenever this judge tips his cap in the hearings, he tips his cap every time. He'll tell you how he's going to rule. I mean, just like in the motion for Franks, once he said, probable cause every day, twice on Sunday. If you got DNA on the knife sheath, you got probable cause. Well, we pretty much knew how he was going to rule on those things right then, but I held back hope. But by bringing up the Lori Vallow case, the lack of discovery, and why they removed the death penalty in that one in the hearing, the judge himself bringing it up, I believe is the best chance. And I've always thought that since that day. So they're bringing it up now. I don't know if maybe the autism spectrum disorder may, correlate to the lack of discovery and removing the death penalty. But the removal of the death penalty is very important for the jury selection so that we can get a fair trial here. Now, let's dig in a little bit more into the autism spectrum disorder, because this one is going to be a big deal, especially in the media right now. there's going to be a big deal for a couple of reasons. The first reason is there has been a recent case down in Texas where they were going to execute a man who had autism spectrum disorder, and the state Supreme Court stayed his execution. So I'm going to read you an excerpt from that case because that is very recent precedent. And I imagine this late in the game, the reason the defense got the neuropsychological and psychiatric experts in to diagnose Kohberger with autism spectrum disorder, and it hadn't happened before this, was because of that particular ruling in Texas. So that, I imagine, initiated them getting the diagnosis so that we could be where we're at right now. So let's look at that real quick. All right, you see, this is an article from the Innocent Project. We like them. And this is about Robert Robertson. You can see Robert Robertson over here. Pretty sad story right here. Mr. Robertson, an autistic father, is on death row based on the discredited shaken baby hypothesis. Robert Robertson, a special education student when he dropped out of school after the 9th grade, and a person with autism spectrum disorder, is an innocent father who has spent over 20 years on death row in Texas for a crime that never occurred. In 2002, Mr. Robertson's 2-year-old, chronically ill daughter Nikki was sick with a high fever and undiagnosed pneumonia and suffered a short fall from bed. Hospital staff did not know Mr. Robertson had autism and judged his response to his daughter's grave condition as lacking emotion. Mr. Robertson was prosecuted, convicted, and sentenced to death under the now discredited shaken baby syndrome hypothesis. I remember shaken baby syndrome. They used to talk about that a lot. They thought shaken baby syndrome was was in correlation with sudden infant death syndrome. Mr. Roberson would be the first person in the U.S. executed based on the debunked shaken baby hypothesis unless the courts or Governor Abbott intervenes. On October 17, 2024, the day of his scheduled execution, Mr. Roberson was issued a temporary reprieve, recognizing that the lawmaker's case raised important separation of powers questions that should not be rendered moot by Mr. Roberson's execution. The Texas Supreme Court reinstated the temporary restraining order requested by the Texas lawmakers. On September 17, 2024, Mr. Roberson filed a petition for clemency, which contains new medical and scientific evidence showing that Nikki actually died of severe viral and bacterial pneumonia that medical professionals missed in 2002, not because of any abuse. Her illness progressed to sepsis and then septic shock, a process likely precipitated by the dangerous respiratory suppressing medications that she was prescribed during her last days, all of which has now been established by detailed reports from highly qualified medical specialists. To date, no court has been willing to consider 3 new expert reports showing how Nikki died of pneumonia, proof that Mr. Roberson is innocent of any crime. So anyway, it goes on to talk about he did get a stay of execution from the Texas Supreme Court. So this case right here, his stay of execution, I believe, was not based on the evidence of the case, but it was based on the fact that he had autism spectrum disorder. So that's why the defense would want to enter a motion for leave to enter this in to try to get the death penalty removed. Now, that's the first part. Now, the second part, though, this is the part that you're going to have to be aware of and prepared for, because this is what you're fixing to get slammed with in mainstream media. Okay, so this is what you're about to see plastered on every headline as it relates to this case by the mainstream morons and the guilters. You can see recipe for a serial unaliver. Childhood abuse, autism, and head injuries are more common in murderers, study claims. And they'll go through the fact that 28% of murderers were thought to have suffered from autism spectrum disorder. And 21% had suffered definite or suspected head injuries in the past, and of those killers with autism spectrum disorder and a head injury, more than half had previously experienced psychosocial stress. But researchers stressed that having autism spectrum disorder or head injury alone were not linked to psychopathic tendencies. But anyway, they're gonna start plastering this because this is some documented research that has been going around for a while. And you're going to start hearing Kohberger, unfortunately, associated with people like the dangers of posthumous diagnosis and unintended consequences of facile associations, Jeffrey Dahmer and autism spectrum disorders. So you're going to start hearing all kinds of crap about autism spectrum disorder, how it relates to serial unalivings and mass unalivings, and how 28% of people with autism spectrum disorder are likely going to commit those things. And I just want everybody to know about it here first, because when you hear it, you know that you're hearing a bunch of BS. And it's important to understand that because we're basing our determination not on any of this crap, but on the facts of the case and the evidence that's been released in the court information and in released leaked video footage. So be prepared for this crap, though, because it's coming. But it also lets me in on exactly what we were wondering in these previous court hearings and why they kept bringing up medical information. Because when you look, for example, okay, so here's the transcripts from the closed hearing. And when you get down, this is Leah Larkin's testimony. When you get down here, especially to this part where she says, and this is Ann Taylor talking to Leah Larkin, what is Prometheus or Prometheus, however you say it? Prometheus is a third-party site, so it's not part of Ancestry, not part of MyHeritage. Actually, MyHeritage owns it now. It's a site where you can take the S&P profile that you get from any of the companies and upload it to the site. And it will basically look for medically informative S&Ps in your profile. And it will do reports on them. I think it's like $12. And it will do a report of all the S&Ps that you have in your profile. If you had my S&P, you could do that and find out. Yes, I can do it. And if somebody has done a genealogy test for $12, I can put it into the Prometheus system and get traits, reports, and health reports. How extensive is that information you could get? It's pretty comprehensive. I mean, you will get reams and reams of reports. I should say that. How do I put this? There are a lot of traits that are controlled by multiple genes. And so if a trait is controlled by multiple genes, I can't say for certain, yes, you're going to get Alzheimer's or you're not going to get Alzheimer's. It's more of a risk factor. But you can look at multiple reports and see if they're, for example, giving you an increased risk of Alzheimer's or what other traits are in the system if you have an increased risk of breast cancer, prostate cancer, or anything else out there. So whenever the prosecution in that open hearing kept asking, there's nothing in here where they looked at medical information, right? They've said it probably 50 times in the closed and open hearing. This is what the defense was alluding to. They were alluding to the fact that once the FBI got Kohberger's, this is another reason why you know that they went into GED Match and got Bryan Kohberger's actual sample that he had uploaded. And then they took it, uploaded into Prometheus, and they got all of Bryan Kohberger's medical factors. And in there, I'm sure it showed them, and that's why the defense is pounding this stuff right now. It showed them that he was predisposed for autism spectrum disorder. So the law enforcement thought they were going to be able to use that as another reason to convict him. They're not looking at the facts of the case. They're looking at all the things that surround the facts of the case that looks like they could get a conviction. That's it. You got to know that stuff before it happens, though, because you got to be prepared to combat it. Get out there in them comment sections and combat that stuff. But that's where we're at on this stuff. Now, the judge, I believe, is going to have to rule in favor of a motion for leave before he will actually, listen to and schedule a hearing for that, motion to remove the death penalty based on autism spectrum disorder. So while I believe there's a very good argument for removing the death penalty due to autism spectrum disorder because of what the Texas State Supreme Court just did with the guy in Texas, Mr. Roberson, the judge would have to grant the motion for leave before he would hear that, though. And that's the part that I think will be likely for him to not accept, is the motion for leave. And if he doesn't accept the motion for leave, then he can't actually hear that motion. But the motion to preclude is something totally different. So that is the one that I'm thinking we've got the best chance of getting the death penalty removed for. And remember, this is just real simple. The FBI's cast on Kohberger says he left his apartment and headed 7 minutes towards Wawawe Park. When you log that on the map, 7 minutes towards Wawawe Park, and then you take all the possible routes back to Moscow, the only route that would get him there before the vehicle that they're saying was involved in this was sighted on Indian Hills at 326 and on Ridge Road at 326, they're saying is the same vehicle sighted in two different places at the same time. The only way that Kohberger could get there and be either one of those vehicles is if he took a direct path right back through Pullman across 270 into Moscow, where he would have been caught by about 8 of those cameras that they say they didn't catch him on. So he didn't go that route. And when you take that route out, there is no possible physical way that Kohberger could have made it back to the King Road neighborhood to be any of the vehicles caught on camera at 326. So it is not Kohberger. That is enough proof right there to prove it's not him, because it does not align with the state's case. That is very simple. Then you take the fact that there's no way that somebody went in there for 8 minutes and committed an atrocity of stabbing 4 people, unaliving them. And then I don't care what anybody out there says. When DM's statement says that she's seen the guy carrying a vacuum cleaner, you can't assume it's a kill kit. You can't assume it's not a vacuum cleaner. If she says she's seen a guy with a vacuum cleaner, then you got to take what she says according to the judge. She said her statements were consistent. So if she says she's seen him with a vacuum cleaner, he had a vacuum cleaner. So there's no way he's going to unalive 4 people and clean things up with a vacuum cleaner and then walk out. But that leaves another thing for us to consider. DM says the guy walked up and stared her right in her eyes. She said she knew that she seen him, looked her right in the eyes, and based on the footprint, he was standing about 2 inches from her face. Now, she stared at a guy with a ninja mask, dressed in black, 2 inches from her face, staring her in her eyes. She can see what's in his hand, right? She can see it's a vacuum. She knows if it's a vacuum type object because she's an inch from him. So when you take all that into consideration, there's no way that somebody could do that by themselves in 8 minutes. Then it's not Bryan Kohberger. And then we've got all the other evidence as it relates to, I don't care what anybody says out there, and it blows my mind, and nobody else has jumped on this. I've taken every piece of Linda Lane footage on the internet, and I've gone to 350, and I've listened to the guy get out of the car and rack his gun and then walk towards the King Road residence at 350. He then returns to that same vehicle at 323. At 423. Now, the law enforcement says the crime happened between 4 and 425. We've got a guy getting out of his car, racking his gun, walking towards King Road residence. Nobody else out there is talking about it. I've listened to every video of Linda Lane out there. That is in there in every video. The old 2-year-old ones, the ones that are the new ones, that did not get added into it later. That noise is in there. And the best video to listen to that is actually from a super guilter, a guy named Jeff H. that most people out there know. I don't mind Jeff H. I think he's actually a pretty cool dude. He thinks differently, but that's okay. He really believes what he's thinking, so I can't fault him for it. But he did an enhanced audio version of that, and that's where you can really hear clearly the click, click. That is a gun, y'all. Somebody got out of their car, racked their gun, headed to the King Road residence. So if that's not enough proof of an alternative suspect for you, I don't know what is, and I don't know why anybody else out there isn't presenting that, because that is real. You can see the guy, you hear him rack his gun, then you watch him walk to the King Road neighborhood. Give me a break. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. I hope to have another one out for you today as well. Pavarotti's out.
until